Statistics.
So the next case we rely on in order of time is ranks, and that's in A2 tab 24, page 513.
So could you give the reference again?
So tab A2 tab 24 513. So the brief facts of ranks were that the defendants were selling thousands of CDs which had Microsoft Windows and Office software on them. The defendants claimed that they were selling backup copies which had been made by the original acquirers who had damaged their original media. That was the defendant's claim. In fact, if one looks at paragraph 20 on page 518, the referring court had taken the view that they were counterfeits and not backup copies, presumably because it would be rather unlikely that so many people had lost the original media and all they had was backup copies. Anyway, so that was a rather unusual factual background. The Latvian government said, why are we even going there? But the court said, well, we have an obligation to answer. Now, it's a short point, but the relevance for the purposes of PI2 is that although UseSoft predated Nintendo, and although the software in issue clearly had a GUI, the court in ranks endorsed, the same software as we're dealing with here, the court endorsed UseSoft at paragraph 34 to 38 at pages 519 and 520 without qualification, 2 years after Nintendo. So that's a very short point. But the decision was that you can't resell a backup copy. But there, be that as it may, that was what they did, is they endorsed UseSoft CJU. The next case is, of course, Tom Cabinet, and that's in bundle A3, so we need to change bundles for those of us working from the paper to A3, first tab 28. And it's important just to bear in mind again what the facts were and the backgrounds of this were. I'm sure you've got them, but the point was Tom Cabinet had a website from which members of its reading group could download ebooks. It obtained the books in various ways, including from members of the book club who were encouraged to resell the books they'd obtained from the club back to the club. So in a sense, the copies could circulate round and round and round within the club. And if one reads the Advocate General's opinion, and I won't take you to it now, but what the Advocate General does is at some length explain the difference in principle between an e-book, which you can read probably once, and then you're not interested in, and it could just be circulated, and a computer program which may have a more lasting existence. Now, why we need to look at this is, of course, it's highly relevant to this case, and the tribunal considered it in detail at various places in the judgment. But if I could take you first to what the questions referred to, which, well, perhaps have a look, go back to page 649, sorry, I'm jumping around. 649 is the summary of the facts, and I've endeavoured to, 648 and 649. That's the summary of the facts, and I've endeavoured to summarise them even more briefly. But the important thing is to look at the questions referred at paragraph 30 on page 649, And the first point to note is that they concern Article 4 of InfoSoft. So the first question is Article 4 of InfoSoft to be interpreted as meaning any form of distribution or sale? And then you can see the same question is at 2, Article 4 of InfoSoft. But if one turns over the page and looks at 31, paragraph 31, at 450, the court reformulated the question on the basis that the duty of the court was to interpret all provisions of EU law which national courts require in order to decide upon the actions pending before them, even if those provisions are not expressly indicated in the questions. It's the usual thing that the Court of Justice is not bound by the questions, but its job, and of course we make that point that that would have also applied in UseSoft CJEU if they had thought in UseSoft CJEU that it might have been relevant to consider the Information Society Directive. So the reformulated question is at para 34, which is to say the question is it a communication to the public, or is it a distribution to the public? In other words, is it an Article 3.1 case or an Article 3.2 case? And then after that, what the tribunal did in our case is go to paragraph 45 of the judgment and note that what the court said is actually the question was about the wrong article in the case of e-books. It should have been an Article 3 question and not an Article 4 question. Part of the reason for that is what in reality an e-book was. Next, if we move to paragraph 53, and this is the paragraph you looked at yesterday, the court then refers to the software directive and UseSoft CJEU. But then at paragraph 54, they say, as the referring court correctly points out, and as the Advocate General noted in paragraph 76 of his opinion, an e-book is not a computer program, and it's not appropriate, therefore, to apply the specific provisions of the software directive. And as I say, that was an analysis of the characteristics of an e-book as compared to the characteristics of a program. Then at 57, and jumping ahead, so 55 they talk about the software directive, and then at 56 they say the assimilation of tangible and intangible copies for the software directive was not desired for the Information Society Directive. So they make the point that it wasn't intended to assimilate them. But then at 57 and 58 the court noted that there are different economic and functional considerations applicable to computer programs on the one hand and e-books on the other, which justifies a different treatment. So that's 57 and 58. Again, looking at the substance of what the work, the complex work may be. So a computer program may be a necessary part of the e-book. It comes out at 59. Even if an e-book were to be considered a complex matter, comprising both the protected work and the computer program, for the protection under the software directive, it would have to be concluded that the program is only incidental in relation to the work contained in such an e-book. As the Advocate General noted, 64, an e-book is protected because of its content, which must therefore be considered to be the essential element of it, and the fact that a computer program may form part of an e-book so as to enable it to be read cannot therefore result in the application of those specific provisions. So that's the way the court analysed it, and we say that approach is entirely consistent with our approach of assessing the work as a whole and deciding where it lies on this spectrum between works, complex matter, in which the essential element is a book or something like that, and at the other end of the spectrum, works where the core is a program.
One has to infer from this what the position would be if the balance had been the other way.
One has to infer from it. They
It's
don't.
not express,
No.
but it's pointing in a direction. This is still InfoSoc because it's such software as exists is incidental and it's not necessary.
Yes.
If it were the other case, if it were otherwise, then it's the inference we draw from that.
That's what we say is the inference to be drawn, and the line of authorities suggests that that is the correct inference to be drawn. But as you say, you have to infer it from this passage. But that's a reasonable inference, particularly in the way they've expressed 59. They didn't, in a sense, as they could have said, well, as soon as it's got any InfoSoc material in it, that's the end of it. They performed an assessment. And having done that, the conclusion was that what Tom Cabinet was doing was not permitted, because Tom Cabinet was permitting downloads of the book from its website, and that was an Article 3 communication to the public.
And because UseSoft is endorsed here, and UseSoft paragraph 44 refers back to the hotel.
Yes.
You would therefore say that you look at the whole.
Yes.
And you decide where the balance lies.
Yes.
So the inference is supported by the cross-reference from UseSoft back to Club Hotel.
Yes.
Well, is it the same whole? And the Club Hotel whole was the transaction. That's right. Not the matter. That's right.
Yes.
Why does Club Hotel say you look at the matter as a whole?
Well, the transaction as a whole.
No, I get that.
But the transaction as a whole, in this case, is the sale, permanent disposition of a complex work comprising both programme and non-programme material. That's the transaction we say you have to look at as a whole. And you have to ask yourself whether that transaction as a whole is one that falls under the distribution right of the software directive, because looked at as a whole, it's that, or whether it's under the InfoSac. So yes,
Just looking at the paragraph 44 of UseSoft, it refers to the two operations must be viewed as a whole, which is the downloading and then the copying, the two ingredients of the user rights, which were the indivisible whole, the two operations.
yes.
So it's the two copyrighted operations.
In fact, the way they used Club Lutraki in UseSoft was slightly different.
It was.
Yes. In fact, I'm suggesting it's more directly
But then in paragraph 44 they say see by analogy.
Yes.
So they're not saying the Club Hotel is squarely on point.
No.
They're saying it's analogous.
But that means. Yes, but our submission is closer to UseSoft. There's a single transaction which has got the two elements in it. Yeah. But absolutely, they're only using it as an analogy. But nevertheless, it's a useful analogy that you've got to look at the thing as a whole.
But they're drawing a principle from
yes.
it about the holistic overviews.
Yes.
It applies. Anyway.
So with that fairly quick canter through the authorities, can I just take you to the judgment? And I'm only going to just show you a few passages in it. So that's in Core 12, page 189, 198, I'm sorry. So paragraph 171, there's a discussion of Nintendo Tom Cabinet in Club Hotel. And we say that that is a correct analysis of those three authorities, as I've submitted to you this morning. Then at 178, there's a discussion of the effect of Microsoft's approach, and that makes the point that applying exhaustion by dividing up a product into different copyright works and then applying different rules of exhaustion ignores what's actually been put on the market in the EU, right holders' consent. We say that's also a correct analysis. And it's also correct to say that it would divorce the principal exhaustion from reality. And then at 180, the tribunal notes that it would, the Microsoft result would be contrary to the purposes of the software directive, as explained in UseSoft. Finally, in paragraphs 181 and 182, the tribunal dealt with the Article 12A point and Article 8 point, which I addressed you with early on in my submissions this morning. So we say the analysis of the tribunal is right on PI2 and supported by the authorities. Now what I'm going to do now, if I may, is move to PI1, and then if there's time at the end, I'm going to come back and have a look at some of the grounds of appeal, but I'd like to move on to PI1 now. So just to understand how PI1 arises, it's because a large proportion of the Microsoft enterprise software products sold during the relevant period was subject to volume license arrangements. And the enterprise agreement and enterprise enrollment agreement, that's the documents we saw at tabs 12 and 13 of supplementary bundle, and I'll have a look at them, were the license terms predominantly available to the large enterprise customers during the relevant period. So businesses reselling Microsoft enterprise software in bulk could not, in practice, avoid dealing with in software the subject of these agreements. And you'll have seen the difference between the parties on this. We say individual licenses can be sold. Microsoft essentially says, well, you can sell them en bloc, provided you do it in exactly the same quantities as covered by the customer's original enrolment. And there's a reference for that. That's paragraph 23C 3 to 23C4 of the re-amended defence at C, tab 16, core bundle, tab 16, page 256. So that's the difference between the two of us. Now what I'm going to do is to begin by looking at the law and make some submissions on some of the cases, and then I'll come back to look at some of the provisions of the agreements and some of the transactions. So far as the law is concerned, can I tell you what our four core propositions are, some of which I don't think will be in dispute, one of which will certainly be in dispute. The first is that a right holder cannot contract out of exhaustion. That's the first principle. Secondly, exhaustion arises on a copy-by-copy basis at the time of first sale. I'll elaborate on that, but the short point is that's exactly what the directive says. When it's
Just formulate that again. Copyright.
Copy-by-copy basis. In other words, when you sell a copy at the time of sale, the rights to that copy are exhausted.
So exhaustion operates on a copy-by-copy basis.
On a copy-by-copy basis, and it happens at the time of first sale. That's when the right is exhausted. The third point, which is where the big difference between the parties is that Oracle Court of Justice doesn't preclude the resale and use of copies of software which form part of a larger volume purchase. Rather, it's concerned, and this is where the splitting point comes in, that the number of copies in use is not increased by the resale. And I'll explain when I come to it how that arises. And the fourth point is it doesn't matter for the purposes of exhaustion if by buying something in bulk, in volume, the original purchaser gains a better price than if the copies were obtained individually or in small quantities. So first, contractual restrictions. We say that can't be in doubt. We deal with it in paragraph 88 and 89 of our skeleton, but perhaps if I can just pick it up in the judgment at 89 to 91, that's at tab 12. Page 177. So in paragraph 89, the tribunal refers to Peak Holding, and that's a trademark case, but it lays down a general principle of exhaustion of rights in paragraph 49. You can see that from page 178. Stipulations in a contract of sale can't preclude exhaustion for the purposes of the law of the EA. And just for your note, although the Advocate General's opinion is referred to there, in fact it's confirmed by the Court of Justice in paragraphs 54 and 55 of the judgment in that case. And then so far as the software directive is concerned, the proposition comes from UseSoft, and that's the next paragraph in the judgment at 90, where the tribunal referred to paragraph 77, and it refers notwithstanding the existence of a contractual terms prohibiting further transfer. So that's a proposition of law that can't be in doubt. Exhaustion operates to exhaust, and you can't try to get around it by all manner of ingenious contractual terms. The second point then is exhaustion arises on a copy-by-copy basis, and a convenient place rather than to take you to multiple authorities is to look at our skeleton, which is at core, where's our skeleton? Core 10, isn't it? It's core 10, paragraph 81. I've written core 19, it's core 10. Page 139. So we've set out why it arises on a copyright by copy basis. It comes from the actual wording of Article 4.2, the first sale of a copy of a programme by a right holder will exhaust the distribution right of that copy. And then references made to ranks, and then a passage from UseSoft CJEU is also referred to. 61 concerns a copy of the computer program itself and the accompanying user license. So that's the timing and the nature of the exhaustion, and it happens automatically at that point, notwithstanding any contractual restrictions. And so once a copy is sold, that distribution right's been exhausted, and it can be resold and transferred physically in the case of CDs and DVDs, and essentially notionally in the case of intangible copies, because the first acquirer doesn't actually pass that copy to the subsequent acquirer. What happens is it sells the right, the license, but as UseSoft explains, the subsequent acquirer gets the copy from the right holder's website, for example. So it's a notional copy moving from the first acquirer to the subsequent acquirer, but the important point is that the number of copies in use should not be increased. So then our third proposition is what UseSoft says and what it doesn't say. And for that, I'll need to go back to UseSoft itself and have another look at what the software consisted of. So that's at A2, level A2, tab 20, 427. If I could pick it up again on page 456, sorry, page 456, at paragraph 21 again, to try to unpick what is being said here. But perhaps if I can, first of all, explain what we say is happening, and then I'll explain and what the court decided, and then I'll come back and see how that ties into the judgment. So what we say we were dealing with here is client software or client server software. The database software is installed on a server and run there, and that manages the database. That central database is then accessed by client workstations who can place queries on the server and get responses from it and do other things. And the point we make is, I'll explain where this comes out. There were two rights covered by the Oracle license. One was the license to store and run the server software permanently on the server. So that was one right you needed, because you got to install the server software and run it. And the other right was to allow a certain number of users to access that server. And the first right was just a single right for that piece of software, the server. If you bought one server software, you had one server, you had two. But in relation to the second right, this is where you have the user licenses, and that's where we get from 22 the point that you have to buy them in batches of 25. So if you had 10 users, you needed a 25 user license, and if you had 27 users, you needed two 25 user licenses. And again, I'm just explaining what we say this case decides. But what the CJEU decided was you could resell the copy on the server and stop using it, and a new acquirer could install and use it. That's what you could do with the server software. That much is clear. But what you couldn't do is split the 25 user right and sell a portion of it. So what you couldn't do is have a copy on the server and say, well, I've got 25 users I can use it for, but I only need 12. So I'll sell off 13 to somebody else, and they can use it to access a server. And the rationale for that was that if you did, you would have to have two copies of the Oracle software, server software. One would be on the original acquirer's server, and one would be on the server of the person acquiring the software. In other words, what exhaustion in UseSoft CJEU arises in relation to is copies of software that have been sold, but not bare user rights, which is what the 25 user licenses were dealing with. So going back then to page 456 and 21. The language isn't as clear as it might be, but we say it's plain enough that what it says in the fourth line down of 21, the software is not with what is known as client-server software. The user right for such a program, which is granted by a license agreement, includes the right to store a copy of the program permanently on the server. That's the server copy, and to allow a certain number of users to access it. And then there's a talk about the maintenance agreement. But then at 22, it's then dealing with the user licenses. Now, could I then take you to paragraphs 79 onwards of UseSoft, which is at page 464.
So your basic point between 21 and 22 is it's one right to use on one server, but actually it involved two licenses if you wanted 50 people.
Yeah, it was one right to use on one server, then you've got to give the users a right to access it,
So that,
a number of users, and those were the ones that were the user rights, if we call it that way. Those were contractual sort of user rights, but you had the server. You can't do this without having the server. Yeah. If you then look at what is said in 69, which is at page 464, we say that supports our submission in this regard. So what they said 69 is that if the license acquired by the first acquirer relates to a greater number of users than he needs, that's the user part of the license, as stated in 22 and 24, the acquirer is not authorised by the effect of exhaustion to divide and resell only the user right for the computer program concerned corresponding to a number of users. And then and this is how it's explained, is the original acquirer who sells a tangible or intangible copy must make his own copy unusable. And then it says, in situation as that mentioned in the preceding paragraph, the customer of the copyright holder will continue to use the copy of the program installed on his server and thus will not make it unusable. In other words, if you do sell off the user right, a part of a user right by 12 user right, you are not selling your server software, you're still keeping your server software, and therefore you have two, you need two server licenses.
I see. So what you say this is talking about is a case in which the acquirer has acquired server software and, for the sake of argument, one 25 user license for 25 users who can access his server. But he doesn't need 25, he only needs 10. So he thinks, okay, I'll sell 15 user licenses to somebody else. That other person would then, in order for those to be of any use, sorry, too many uses of the word use, but never mind, they would have to have their own server software.
Yes.
And that's what's being referred to at the end of 70.
Yes.
And they would, and that would mean the only way that would work. And so the original buyer of all of this should have shut down his server, but of course that's not what he wants to do. He wants to keep his server going.
Wants to keep it running. Yes. And that really then is that line of reasoning is then carried on in para 71. It then says, moreover, even if an acquirer of additional user rights, it's here referring to that user right, didn't carry out a new installation and hence a new reproduction of the program on a server belonging to him. So what happens if I own a server already and I just buy those 12 or 13 user rights, notionally, the exhaustion principle would in any event not extend to such user rights. So that's why they're referring to user rights. In such a case, the acquisition of additional user rights does not relate to the copy for which the distribution right was exhausted at the time of that transaction. On the contrary, it's intended solely to make it possible to extend the number of users of the copy which the acquirer of the original rights himself has already stored on the server. So we say it's quite simple. You can't split those user right permissions, those contractual permissions, but you could resell your server software.
Is 71 talking about this situation? Looking at 69 to 71, when it's referring to if the license acquired by the first acquirer relates to a greater number of users than he needs, and then you read 71, is what's being talked about there a situation which, well, it's the same as before, so customer buys one of these licenses, server plus a 25 license, but only has 10 users, so it only downloads 10 copies for their users. So he's got 10 copies of the user software, and then he thinks, oh, but I've still got 15 licenses, not copies of software, just licenses. So he sells those 15 licenses on, and what he hasn't had is a copy of the software. And you need the software copy itself to have been sold as well as the license in order to exhaust it.
Yes.
And that's what's being, is that what this is about?
Well, I think what it's about is this: is in the case of the so-called user rights, you're not. Oracle isn't selling the copy. What it's selling is the bare user right, the right to use. What you can sell though is the server. So I think it may be the same point as you're putting to me, but it's not as clear as it might be. But if you unpick what is being said here, we say it's very clear what they're talking about and the rationale. You mustn't increase the number of copies of that server software.
It's not just the server software, because that's why it's talking about additional user rights.
Yes.
In the middle of 71, in such case, the acquisition of additional user rights does not relate to the copy for which the distribution right was exhausted at the time of the transaction, because he's only got 10 user copies, even though he's got 15 extra rights.
Yes, although the problem is that what that is whatever it is you've got in terms of user rights and what you can do on your workstation, you've only got what your right to access the server is a mere user right to access the server, and it's focusing on that point there. That's what we say it's dealing with. It's saying you can't sell user rights. You can't put it another way. What Oracle sell is two things: the server software and user rights. The user rights are contractual rights, and those can't be exhausted. But the copyright in the server, that can be exhausted by the first sale.
So claim from 71 that they're only discussing one copy.
Yes, exactly.
So the only, maybe I misunderstood this. So the only copy of software that's around in UseSoft is the server.
Well, yeah, that's what the Court of Justice is. Yeah, that's what the Court of Justice seems to be talking about in this case, is the copy of the software on the server, because that's why they say that at the end of 70, the situation as mentioned in the preceding paragraph, the customer will continue to use the copy of the program installed on his server and will continue to use that. So that's
That's 70, but 71 says moreover. So you might have thought it's talking about a different set case from the copy staying on the server, but then it still talks about the server again.
Well, I think what it's talking about there is, suppose hypothetically that the new acquirer already had a copy of the server software. What then?
Yes.
And what it's saying is that user right to access that copy of the server is not something that gets exhausted.
Oh, I see, and that's what the sentence says. In such case, the acquisition of additional user rights does not relate to the copy of the server software, I'm adding,
Yes.
for which the distribution right was exhausted at the time.
Yes.
I see. Yes,
So
I see.
you've got two. So
Yes,
problem
so
one,
got you.
yeah, I think you have it. Problem one is that you just envisage the original acquirer with one copy of the server software and the user rights. If you sell that, you've got to stop using it and the new acquirer can start. But there is another scenario where the new acquirer says, well, I don't need another copy. I've already got one. What's the problem? And what the Court of Justice is saying that those user rights can't be exhausted.
Yes.
Because it's quite commercially quite possible that you're selling to someone who's already got licenses and therefore a right to install on the server.
Yeah.
So they're just acquiring the additional user capacity.
Yes. That's
I
what,
think
what
that's
that's
the
what we
thing
say
that counts.
71 is doing, because it talks about even if the acquirer of additional user rights didn't carry out a new
Hence, no new reproduction.
Yeah.
Yes.
No, it's saying you still can't do it.
You've got our submission on that. It's clear. We say you can sell the server software. That's the exhaustion principle, and you can sell it even if it's given to you in intangible form. The user rights are user rights, and those aren't the subject of exhaustion. They're bare user rights.
So not a model of clarity, this is it.
No, it's not a model of clarity. No.
So in a similar vein, think about one of the points you're making, Mr. Hicks, at least the way I'm thinking about it now, is because of the fact of UseSoft and the need, the whole interaction with a server, and there's only ever been one copy in this case, as it were, the UseSoft scenario. There's only ever been the purchase of one copy through one license of the server software.
Yes.
That's very important when you're trying to understand what, if anything, it says about disaggregating copies, because no one thinks you can disaggregate one copy of server software into multiple server copies.
That's right. Yeah. You can't split your one copy of your server license, because then you end up with two.
Yes.
And yet paragraph 21 makes it plain that the way that the users access the copy is by downloading.
That's right.
Yeah. I accept that it's not a model of clarity, but I think it is clarified once you get to 69, 70 to 71 to see what they're talking about.
And the BJH construed these paragraphs in this way.
Yes, I'll take you to UseSoft 3 then shortly, where they deal with that paragraph. But perhaps if I can deal with the next proposition, is it doesn't matter, and then I'll come to the BGH UseSoft 3. The fourth proposition is it doesn't matter for the purposes of exhaustion if by buying licenses in volume, the first acquirer obtains a better price than if they were purchased singly. And the rationale is that the seller has had the opportunity to obtain appropriate remuneration, and that's enough for exhaustion. I mean, a simple example, nobody suggests that if I buy 1,000 copies of the White Book at a discount price, Sweet Max will be very pleased about that, I can't sell them off. That's the way the world works. The distribution rights exhausted when the copy is supplied.
It's an opportunity to obtain such remuneration as you can
Yes,
for that number of usage rights,
yes,
and you take into account the correct legal regime as it stands, and you would factor in everything that's in that product, including the non-software rights, the software rights, the possibility of resale, etc., etc. You get your return on investment up front
yes,
once,
exactly.
whatever it is.
Whatever it is, but what you
It's not about measuring the bargain, it's about the existence of the right to recover something.
exactly, and that's the point that we discussed earlier in paragraph 63 and 73 of UseSoft. It's the first sale allows.
There's never been a defence to an act of exhaustion to say, I didn't really get very much money for it.
No, because you chose to sell them in that way.
That's freedom of contract.
And you will take everything into account, the fact that they might be resold or might be used or not. But you may offer a reduced price for greater volumes because that's economically desirable for you. Could I then go to UseSoft 3, which decision of the BGH, that's in A449. page 998, sorry for people wanting to have a digital copy, 998. So there's the head note A, B, and C, and D, which summarises the BGH decision. So
Is this the head note provided by the court?
I think it must be, yes. This is the official translation. It seems to be the practice of
It's
the
not
BGH.
co-pilot or something like that.
No. The practice of the BGH is
It
to
generally provides summaries. doesn't it?
yes, it's a bit like the Supreme Court now gives you a short summary of the decision. Yeah. So there's no just so you can see. A is distribution right is exhausted, whether it's physical data carriers or downloading. So that's standard. Then B is the contract point. So I'm sure you've got the terminology, but what we're using in this case is UseSoft CJU is the CJU decision. UseSoft 2, referred to in head note A, is the return of UseSoft CJU back to the German courts and its eventual destination at the BGH. And UseSoft 3 was the same UseSoft company, but this time dealing with Adobe software. So then over the page at 999C, is dealing, and we'll come and have a look at this, it's dealing with independent copies. That's our copy by copyright copy point. And then D is another reinforcement of the no contractual restriction point. So if I could then pick it up at page 1001, I took you to paragraph 1 to show you that this was Adobe software, and of course you've got the point that must have a GUI. Then at 3 in the middle, the software was sold to, is educational software, was sold to educational institutions at a discount. That's 6 lines down. So that's the pricing point. And then the BGH considered the issue at paragraphs 35 and 36 on page 1013. So at 35, there was a complaint that the consent was said to be limited to the use of the software by educational institutions for educational purposes. Its right of distribution was said not to be exhausted with regards to the resale to a reseller here. And then it says you can resell it regardless of that contractual restriction. And then in the middle of, and paragraph 36 makes the same point. And then at 39 and 40, there's the remuneration point, and I think actually at 40 is the point I was discussing with Lord Justice Green just now, that the plaintiff had the option, because it makes its consent to downloading depend upon the payment of a fee. It can determine the amount of the fee based on the scope of the right of use granted. It's irrelevant whether this fee is reasonable. So that's it, you have your chance.
Are we missing some text here? Because paragraph 41 doesn't seem...
No, sorry, I think it's very annoying the way the paragraphs are numbered, but 41 is...
37 is E, this is then F.
Yes,
And then I see, okay.
yes. I don't fully understand. If you look at the original German, they do that. It's partly a translation issue, it's partly a feature of the way that it appears in the original German. But anyway, there we are. We've got these strange numbers and apparently non-corresponding letters, but there we are. So then at 44 is where we come to UseSoft and Oracle, and we say this interpretation of UseSoft and Oracle is consistent with the submissions I was just making to you now. Exhaustion of the distribution right doesn't entitle the initial purchase to split the license acquired and to resell the right to use only for a number of users determined and continue to use the copy installed.
So where are you reading from?
I'm reading, sorry, up 44 on page 1015.
No, I must be. Okay. Just sorry, mistake. Say what you said again then.
So 44 is the server point, and we say that is endorsing the BGH endorsing the submission I've made to you as to what UseSoft Oracle was saying. That's UseSoft CJU. And then and then at 45, the point is made that if, on the other hand, the purchaser's acquired a license that permits use of several independent copies of the programme, a volume license, it's entitled to resell the right to use the programme in question to a number of users specified by it. That sort of ties in with the pricing point. So if you sell 100 individual licenses, then you can split that because the licenses are independent rights.
Subject to the last couple of lines.
Yes.
Assuming the initial purchase has rendered a corresponding number of copies unusable. So
Yes.
you can never increase the absolute quantity.
You mustn't increase the quantity of copies in use, as we say, the principle. It didn't matter in this case because that wasn't, in fact, that wasn't a difficulty in that case. And in this case, the tribunal found there was no evidence that the sellers had continued to use copies.
Does this imply about the number of copies which are then installed on servers? You can see you've got to have correlation with the number of user rights.
Yes, you've got so what 44 is doing, we say, is explaining that you can resell your server copy and you've got to stop using it. But if you keep your server license, what you can't do is just resell the user licenses, the access rights individually, because those can only be used with a server, and where's that server going to come from?
Yes.
But then it contrasts that with volume licenses, as in the case of the Adobe software here. You've got a better price for 40 copies, 40 licenses, so you can resell a number of those licenses.
If you're a purchaser, doesn't that copy go onto your server?
Not in the case of Adobe software, for example.
Okay.
I mean, we're talking here not about, by the way, we're talking about Windows and Office here, which are the versions of the software which are installed on computers, individual computers. We're not talking about Windows Server in this case. We're talking about Windows, the version of Windows we see on our computers.
The way paragraph 44 characterises UseSoft in the sentence that starts after the brackets, where it said UseSoft/Oracle brackets. There it says, if the initial purchaser has acquired a license that permits the use of the copy of the computer program installed on the server by multiple users, that seems clearer to me than anything that I actually read in UseSoft in the Court of Justice, that what UseSoft was about was users using the copy on the server.
Yes, that's why I took it to it. It's consistent with our explanation. We say it's clearer.
When it says the subsequent purchaser of the copy of this program, and that's the copy is the one is installed on the server, which multiple people can use. It's not talking about them downloading it, it's talking about them using it.
Yes. It comes back to the point. You've got a difference between the exhausted copy on the server, which that's it, exhausted copy, the copy on the server, which is exhausted on first sale, and these user rights, which are contractual rights in a sense, to access that copy on the server. I mean, it is fair to say that the CJU judgment is not a model of clarity on the point. What we submit is when you unpick what they were saying, it's clear enough, and that certainly, and our unpicking of it is consistent with the BGH's unpicking in UseSoft 3.
Well, presumably the original language of UseSoft in the CJU was German. German reference. I suppose it could be French.
The language of the case will be German, but the language of the court will be French.
But I think there's no suggestion that there's any nuances of translation. It just is perhaps not as clear as it might be, whatever language you look at it in. But it's clear what we say is the point is that it's a copy by copy exhaustion. That's the key to it. It's going back to the concept that when you sell a copy of something digitally, that's it, intangibly or in physical form, that copy is then immediately exhausted. The rights in that copy are immediately exhausted. Yes, I've dealt with the judge. So that's what I wanted to say on UseSoft 3 and the cases on this. What I want to do now is come back and have a quick, we're doing quite well for time. If I may come back now to have a quick look at the licenses in issue. So could we go to the judgment first, please, which is at C tab 12, page 1, core tab 12, page 171. So apart from what the interpretation of these agreements is, there's a good summary of what the agreements are between 63 and 69. And the difference of view, as explained by the tribunal, emerges from 70, that Microsoft characterises this as a single license providing multiple user rights to access a copy of the product on the Microsoft server, whereas value licensing characterises an agreement to provide a bundle of licenses, and that's the position which is maintained on this appeal as we understand it. Now, we contend that the agreements are clearly volume license purchase agreements that provide the customer with a bundle of licenses, each of which permits download, copy, installation and use of the product, and that's the conclusion reached by the tribunal in paragraph 70 and 71, and also in paragraph 105 of its judgment. Now, ultimately, we say, because we're not in the realm of client-server stuff, and servers, this distinction doesn't matter, because contractual terms cannot limit or restrict exhaustion once it arises. But we do say the tribunal's analysis is correct. And could I take you then to the first agreement, which is the Enterprise Enrolment Agreement at Supplemental Bundle 1, tab 12, page 108. And you've already got, I'm sure, a number of these points, but I could just run through them quite quickly. So you can see on the top right of the front page of page 103, it's headed Volume Licensing. And our short point is that when you read this, what the customer thinks they're getting is a bundle of licenses. And you can see from the second or third paragraph on that page, just above the punch hole, the agreement consists of these terms and conditions and various other agreements. So you get a stack of these documents. But this is the one which is particularly relevant for the purposes of understanding what the license.
Does the analysis of exhaustion turn upon the subjective views of the parties as reflected in the contract? Or is it utterly irrelevant?
Probably not on subjective views, but how you describe something may well give an indication as to what it is the contract's for.
But in determining, yeah, okay, right.
But
What's a copy, for example? Isn't that an autonomous concept of European law?
it is. Ultimately, it must be a matter of substance rather than form, because otherwise you could always get around it.
Sneak your way out from contract.
Yes, the clever draftsman of these things could find all sorts of tweaks, but absolutely you have to look at the substance of what it is. But where you describe something in one particular way, it's not unreasonable to say that's a fair interpretation of what
Part of the evidence base.
Part of the evidence base, part of the background. Volume licensing. So you've seen at page 105, if we could go to the next document, which is at page 110, tab 13. And this is the, I'm sorry, I confused you. Tab 12 was the enterprise agreement, headed up volume licensing. Tab 13 is the enterprise enrolment agreement. And that starts at page 108. That's also headed up volume licensing. So I did confuse you, I'm very sorry. So tab 12, page 103 is the enterprise agreement, and then tab 13, 108 is enterprise enrolment. Again, that's headed up volume licensing, and again, it shows it's part of a stack of documents. Minimum order requirements at page 110, and you can see the way this is worded. Clause 2A says there must be a minimum of 500 qualified users or devices for each enterprise customer, and the initial order must include at least 500 licenses, plural. And then the same point at 2A1, an affiliate must order enough licenses.
I think we were told that the expression of the plural, it refers contractually to a single permission.
Yes.
But is that somewhere contractually set out?
Well, license is defined in the enterprise agreement. Yeah.
Clause 2A.
The definition of clause of licenses on page 103, enterprise agreement. It's the right to download, install, access and use a product. So it has the look, we say, of a right to run a product, to purchase a product.
I don't think that necessarily suggests that the expression licenses must be deemed contractually to refer to a license. So you have a license to one person, you may have multiple licenses to 500.
Yes.
It's the license and licenses.
Yes, that's the point. Is the way it's worded is it looks as if you're buying 500 licenses. That's what it says. Sorry, I've been hopping around too much, but if we look at, I was back on page 110, and this is just, it's just textual analysis, but at 2A, licenses in the plural, at 2A1, enrolled affiliate must order enough licenses, and then at the bottom of the page, at G2, adding licenses for previously ordered product, and then a true-up requirement, H2, you've got to order additional licenses. So it's not, it doesn't read as if what you're doing is expanding the number of users within a license, but you're buying additional licenses. And then if I could take you, so all licenses in the plural, it has that look of purchasing volume licenses, multiple individual licenses. And then at tab 14, we had a look at this, the subscription form. Just so you understand how this works and instructed, is that you've got qualified devices and qualified users, and Office is sold on a user basis, whereas Windows is sold on a device basis, i.e. a computer. So if you look, you've got 22,467 devices. That would be computers on which Windows is installed, and then you've got 22,434 qualified users, actually slightly less qualified users than you've got device. And then if you look at products under Office Professional Plus, if you add in the right-hand corner 20,934 to 1,500, you get to 22,434, which is the number of qualified users. And then if you go down to Windows Desktop, if you add those figures up, you get 22,467, which is the number of qualified devices. And that shows you what we're not dealing with client server software here. We're dealing with the kind of copies of Windows that we're familiar with on our own computers or devices. And then over the page, there's the point at page 118, which is they talk in the middle of the page in that little table, in the middle of the page, quantity of licenses and software assurance. So we say these analysis that the word is correct. These are purchase agreements for a bundle of individual licenses. Then I was just going to look very quickly at the, just so you know where I'm going to go, I'm going to look very quickly at the transactions. It'll take me 3 or 4 minutes, and I was just going to run through the grounds of appeal then on both issues. So the sample transactions are described in the judgment at tab 12, page 174. And you can see, starting at page 72, the sample transactions are run through. And there's no criticism, as we see it, of that summary, and so I won't dwell on it. But if I could take you, so those are the transactions, and at paragraph 106 on page 183. At 106, the tribunal makes the point that there's no evidence that the transactions have resulted in a greater number of copies of Windows or Office being used. There's no evidence to support a suggestion that the first acquirers have not deleted and carried on using the copies they originally downloaded. The first purchaser is no longer using the software concerned. So from that point of view, the requirements are met, no increase in number of copies. Now, what I was going to do then is go back to the grounds of appeal, or actually I haven't looked at the grounds of appeal. So I was going to take you to the grounds of appeal and just run through those. I'm not going to take you to every ground of appeal. We've covered them in detail in our skeleton. The ground, just check where I am in my note. So the grounds of appeal are at core 8, core tab 8, page 90. And as I say, we have covered all these in our skeleton. So 1.1a is Article 8 of the Software Directive. I've dealt with that. 1.1b, Principle of Concurrent and Cumulative Protection of Intellectual Property Rights. That's dealing with a different thing. Of course, a patent and a copyright can exist in the same thing. But we're not dealing with cumulative different intellectual property rights. We're dealing with a single intellectual property right, copyright, and the interaction between the two directives. Article 9 of TRIPS and the WIPO Copyright Treaty and Article 2.5 of the Berne Convention, they don't deal with exhaustion. Nothing that prohibits the EU from deciding matters in the way that we say it did. Subparagraph D, you cannot lawfully alter, eliminate, reduce or undercut the scope of EU legislation. But there are two particular problems with that argument. The first is that it's a circular argument because it assumes that the tribunal's interpretation of the interplay between the two directives is wrong without establishing that's the case. If the tribunal was right as to how exhaustion applies, there's no undercutting. The second is if Microsoft is right, as we've indicated, the exhaustion principle established in UseSoft is itself effectively eliminated, reduced or undercut. So there can't be, that's not a satisfactory argument we submit. It's a question of assessing which of the two directives matters should fall under. Subground E, we don't say that's a principle that helps in this case. We can see that Tom Cabinet decided for the case of books, one regime might apply, but you have our submissions on that. F is the
You
WIPO.
dealt with that, Article 6 and 7 of the WIPO Treaty. You've given us your submission.
I've dealt with that one. G, digital exhaustion, Article 4, and the interplay with Article 4.2 I've dealt with. H is is essentially the same point all over again. Then I'm just running through these. Just 2 is the point that the graphic user interface of a program is protected under the Software Directive. Yes, not under the Information Society Directive. Yes, but I've dealt with that.
Yep.
And then 3 is essentially the same point. Then, so I think all those relate to PI2. Then ground 2 relates to PI1. And there's a complaint that the tribunal used the word product in paragraph 108 of its judgment rather than programmed. What the tribunal said is, on the facts, the distribution and reproduction right enjoyed by Microsoft in the products does not prevent the subdivision and resale of the user right acquired by the first acquirer. So Microsoft doesn't explain why this wording in paragraph 108 of the judgment makes a difference, or is said to reveal any error. It's clear what the tribunal meant. The answer given deals with the sale of a portion of the copies purchased as volume licenses, and there's no authority that the tribunal is fettered by the wording of the preliminary issue, which may be formulated as by the parties. We'd also note, and this is in our skeleton at paragraph 91 onwards, that the preliminary issues felt to be determined in the circumstances of this case. And if one looks at paragraph 92 of our skeleton, we give a list of references as to where Microsoft itself uses the word product in its own trial skeleton. Subground 2(1)(b).
This is just about interpretation of case law.
Well, it says omitting to address, so yeah, omitting to address limb 1. So the first one is apparently is a complaint about terminology, program or product, but it doesn't, we don't understand how that makes a difference. 2(1)(b) is a failure to address two limbs of the question. So can we just see what those two limbs are? That's, we can see that at core bundle tab 12, for example, page 156. So there's a failure to address limb 1 and limb 2. So limb 1 is a license covering a particular combination of multiple computer programs. So presumably that would be a license covering Office, which has got within it Word and Excel and all the products we're talking about. And then B is the essentially the splitting of licenses point. So, as I say, limb 1 concerned subdivision of rights obtained for the multiple pieces of software within Office. But that didn't arise on the facts of this case because there was no suggestion that value licensing split out Office into its individual components. The point was it resold Office with all its program elements. And limb 2 is the license splitting point, and we've dealt with that. Going back to the grounds of appeal at 9, tab 9. Sorry, tab 8. Tab 8. So paragraph 2 sub 2, page 91. This is a complaint about the use of the term notional copy. And we say that was an appropriate term to use to reflect the fact that in the case of intangible delivery of software, there can be no direct transfer of the actual copy. It's encapsulating that concept of not increasing the number of copies. Then, as far as we can see, the rest of 2.2 relates to the splitting of licenses point and the interpretation of what those license agreements cover. Then 2 sub 3 is essentially the same point in relation to bundles of licenses, and 2 sub 4 is a complaint that essentially UseSoft doesn't allow splitting, and I've explained to you what we say on that. Then 2 sub. I'm losing track of where the sub numbers are now. 2 sub 5.
4.
2 sub 4. That's a subdivision point of UseSoft, which I've dealt with. Two sub 5, not entirely clear to us what's being got at there, in the sense we've covered all the UseSoft requirements, and I've explained why we say they're met in this case. Oh yes, sorry, I've got it wrong. And 2.5 is an unpleaded allegation relating to the use of multiple access keys to facilitate resales of Microsoft software. Yes, I'm sorry, I'm getting myself confused with these subgrounds. 2.4 is a complaint about UseSoft. 2.5 is a complaint about the use of multiple access keys. The problem with this allegation is it's not pleaded. The UK legislation dealing with this is section 296ZA of the 1988 Copyright Act. And that raises a wholly distinct cause of action to copyright infringement. As I showed you in relation to Nintendo, it's its own separate right. The first time I'm instructed these were raised by Microsoft was in its trial skeleton. And the tribunal found that these were irrelevant to the preliminary issue, and rightly so. There's no pleaded allegation. They were raised in the statement of facts, but not in the pleaded allegation. No allegation of wrongdoing. But anyway, it's hard to see how this could be applicable. It's dealing with a separate issue, not exhaustion issue, but the Article 6 right. So that takes us to the bottom of page 92. Top of page 93.
That's the remuneration point.
That's the remuneration point, and I've dealt with. And then 4 is just a catch-all. So unless you have any further questions, I've finished more quickly than I anticipated.
Thank you, Ms. Hicks.
Those are our submissions.
Thank you, Mr. Lavey. Yes. Ms. Toms.
If we get to UseSoft 3, I'm not schooled on it. I'm going to, with your permission, ask Mr. Ripton, who is schooled on it. Okay.
We would like that part of the advocacy conducted in German.
Jawohl. Okay, so there are big points and there are smaller points which arise out of my learned friend's submissions, and I will try to not spend too much time on the smaller points, but I will on the larger points. Mm-hmm. So he took you. I'm not starting in the same. I never like to reply by repeating the arguments back against myself in the same sequence.
That reminds me, Mr. Holmes, I do have a question.
Oh, good.
Something's been bothering about this case, which is about the whole structure of the legal framework. And what I'm talking about is Brexit.
Ah, yes.
Because it occurs to me that the way this case has been argued is as if we never left. And we have. And experience shows that often in cases of this kind, at some point during their passage through the courts, somebody pops up and starts saying, oh, well, hang on a minute, what about this or that? And in particular, what about things like departing from EU case law?
Yes.
No one has invited us to do that, and in particular you haven't.
No.
You have, if I can put it as politely as I can, you have at least occasionally come close to hinting at
Yes.
The possibility that you don't agree with UseSoft.
Yes, but I did quickly say.
You haven't made that submission.
No, but there's nothing I can do about it. But may I answer your question directly as to why there is?
No, it's not a why. I'm not interested in why. I'm interested in just making sure that it's clear.
I'm going to reassure you completely on that point. Can you find me the section or tell me what it is? In our skeleton, we've got a paragraph which deals with the footprint, the geographical footprint of the claim, yes. And it also deals with the time frame of the claim. Mm-hmm. And it's agreed between the parties, and that's the basis on which it was fought below. Can someone find that? I'm told it's 19, yes. If you happen to have 19 of my skeleton, it's 102 in the bundle. So the geographical footprint of the claim covers the whole of the UK and EEA. That's the competition claim, of course. The period of the claim runs from 2014 to 2022. The law applicable to the determination of the PIs is the EU law in force at the time of the events in question, and we cite Skykick and Sky for that, where Lord Reid, speaking for all of the justices, said that at 511. And then we put in, not that I think you'll ever need to get to it, but the obligations in articles of the 222 of the Trade and Cooperation Agreement also make it obligatory to apply those conventions and the provisions relating to them.
Yes.
Now, on top of that, the directives, I'm losing track of the phraseology we use for this. They were regarded, I think the phraseology in the early days of Brexit was retained EU law. The directives remain, whatever their current status is, unrepealed and unmodified in the statute book. So if you did a legislation.gov search, you'd find them there. And we are therefore proceeding on the basis that the directives, as interpreted by the case law of the Court of Justice, because we're talking about the whole of the EU, the aim is to find out what the law was that was governing the exhaustion of rights over that period looking back through time. And I believe that is an answer to my Lord's question.
Well, not completely.
Oh, right.
That's not me complaining. I haven't explained myself properly. What I'm bothered about is, I think that means, I don't mind, Mr. Holmes. It's not that. I just want to make sure I've understood what's happening.
Yes.
I think that means that in a different case,
Yes.
if someone was arguing the same facts but only confined to the UK,
Fresh case. Yes.
they might take a different view of the law than you, because, or of your opponents for that matter, because they wouldn't be wanting a decision in which the UK's approach to this body of law is
Right.
different
Right.
from the rest of the EU.
Right.
Neither of you want
No.
that, and you've given me good reasons why. And I'm not for a microsecond criticising anybody for that,
No.
but I am aware that means that one could misunderstand the legal basis of this case if one approached this purely as a UK-focused lawyer who didn't care whether the UK law was the same as EU and was quite happy to use whatever instruments or available tools one might have in a purely UK dispute to argue about the correctness or the to be followedness. It's not correctness, it's whether we should be following various bits of the law flying around in this case. And as I said, to repeat myself, I don't mind, but I do mind to be clear if that is where we are.
I can be clear with you. We've taken the position we have, and it is common ground. I've set it out in 20.
Yes.
There's a corresponding paragraph over there. That's because we're looking backwards, because there's a cause of action for damages for a whole geographical footprint that can only be determined under EU law in force at that time. End of. If I was instructed in a claim now in which the question was, is UseSoft good law? I would argue that it isn't. And by the way, I have to ask rhetorically, the footprint, what would the footprint be of such a claim anyway? There are complications about what the geographical footprint of a claim can now be under a cause of action in the High Court for copyright infringement. What's the case in the Supreme Court? Forgive me, I'm just...
No, it's all right.
The case in the Supreme Court. No, not that one.
The other one.
The other one.
This one is not. There is a case in the Supreme Court, name unknown which.
No. We have case law in which you've been allowed. Okay, long story short, there was a case called Tyburn versus Doyle that I argued in front of Mr. Justice Lyman. That's it. I argued, I don't know.
What is it? We're agog. What is it?
It's Lucas.
I've got to get there. Yes.
I knew it was Lucas.
It's Lucas.
I knew
You
it
mean
was.
you
I
could
wasn't
have
gonna
put me
let
out of
Judy
my
do his
misery,
job.
my lord?
No, I enjoy the misery, Mr. Holmes.
pass on that. I know a cul-de-sac when I see one. Yeah, it's Lucasfilm. Now, there are questions about that because Lucasfilm reversed Tyburn and Doyle. Tyburn and Doyle was Mr. Justice Vinelot. It's one of those subjects which will need to be revisited about quite when and how you can make a ruling here for foreign infringement of copyright. We're not in that case, but my lord is right to foresee that in other circumstances, I would have to say with a fresh start compared with when we left. I mean, we left and then we were in a twilight zone and then we left and then we really left.
Remind me when the date of the last of those was?
31st of
When we-
December 2020, I think.
2020, yes.
Yeah, but then we had
I think that was the final day. And I think if this were purely Section 2 or 18, it would be, up until that date, we're bound by European court authorities.
Yes.
After that date, they may be taken into account, but they may, subject to a rule which could include a judgment of the Supreme Court, which says they shouldn't be followed.
you need a reason not to follow this.
Yeah.
I'm reading it, yes.
But there's a whole load of both this 2018 Withdrawal Act and the 2020 Act, and then there's some regulations, CAT regulations.
True, but then there's the 2023 Act,
Yeah.
Riola. It gets really messy. Suffice it to say that the legislative instruments in the form of the directives are still in legislation.gov.
Yeah.
They only take them down when we either alter them or we repeal them or whatever we're going to do under our new powers. None of that's happened. It's all crystallised around and about the law we've been discussing, and I believe that however you look at it, the rulings of the CJU we've been citing to are binding for the purposes of that retrospective determination.
I think probably only until December 2020.
That's what
But that's the point that Sir Colin Burse is putting to me, because if you had a fresh start after 2020, you'd be saying, well, what's the status of UseSoft? But they've endorsed the claim form. They've endorsed the claim form for it's whatever article it is of the EEA agreement. They've endorsed the claim form for TFEU. They've got their claim staked in the claim form with the EU law backwards, and the CAT entertains it on that basis.
Just to spell it out even more, Mr. Holmes,
All right.
this period that you've shown me in your skeleton
Yeah.
runs up till 2022,
Yes.
not 2020,
No.
and therefore it covers the time when, at least as far as I could see, if you wanted to do so, you could argue about following retained EU law. You haven't done that.
No, we haven't.
I want it to be out and clear, at
Yes.
least as far as I can see.
Yes. We've deliberately
I'm not
not.
advising you what to do.
No,
I'm
no, of
certainly
course
not
not.
doing that. But,
No. We've
you know.
deliberately not done it. We did comb through it, and there are sections in the skeletons below.
Yeah.
We had stuff in the bundles below, but it becomes like a Mandelbrot fractal by the time you've gone back through all those statutes. So we've taken, I mean, nobody's dissenting in my right ear, are they? Are you? No, nobody's dissenting, right? So I'm looking backwards. As Kierkegaard would say, I'm walking into the future looking backwards.
You've got to give me your telescope of time analogy, Mr. Holmes.
Do you like that? I make come for that. That gives us that. Actually, no, I've got no time.
You know we have to rise early today.
No, we don't. Well, we do arise at 4:15, which gives you longer than you were expecting, so we'll stop.
No,
and
it
get
may
on.
not be as long as I need, so I'm going to have to start gabbling again. Right, so you were taken to the WCT by my learned friend. You saw him refer glancingly to those agreed statements. He missed out the word exclusively. Yes, he's right that the distribution right is provided for, but the footnote tells you that it shall be exhaustion of the distribution right exclusively by fixed copies for distribution and the sale of tangible objects. So the word exclusively is what tells you what is to be implemented pursuant to Article 6 WCT. For your note, Article 22 of the WCT says no reservations to this treaty are permitted. No, well, it means that you take the law as it comes to you through that treaty. And you've seen the case law of the CJU in which they stand by and stick by those statements. Otherwise, Tom Cabinet would have made the observations it did. Right, so then you were my learned friend touched on BSA. And he touched on it for the purpose of telling you, well, look, the same judges, not long subsequently, will have had it firmly in mind when they came to deal with UseSoft. And he's right. He's absolutely right. But what is it that they will have had in mind? BSA tells you that the graphic user interface, and it's as simple as that. There's no sort of refinements to do with spectrums of works or where on a spectrum. BSA tells you explicitly that the graphic user interface is not an expression of a program, a computer program. It tells you, this was the case that ruled actually for the first time definitively, then SAS picked it up a year or so later, that's the end of it. The reason the questions were asked by the referring court was because they wanted to know exactly what the position was, and they got the clear answer to that. Graphic user interfaces are not program works or within the scope of that directive. It's an explicit ruling. And it was carried forward, as I indicated in opening yesterday, by Sony Entertainment, where they nailed it to the floor. Now, you are being asked, through the argument that's been presented here by my learned friends and with the decision that's presented to you below, from the tribunal below, you're being asked to say that legislation which applies specifically and explicitly to programs, meaning coded works, you should take that legislation and you should apply it to things which are not within the scope of that, and which, by contrast, by antithesis, are plainly within the scope of Article 4.2 of the InfoSoc Directive. Nobody's quibbling, I don't believe, on the complex matter, complex work. We are all recognising in our respective submissions that the world is full of works which are complex, however you put it. If you want to put it in the way of Nintendo, it's the entire product. If you want to talk about semiconductors, it's the entire product, and so on and so forth. Now, Article 52 of the EU Charter tells you that if you are going to derogate from the right to protect intellectual property, you must do so on a basis that's provided by law. That is in the EU Charter. It's a constitutional right for the benefit of right holders. Where I ask rhetorically is the law, when the law, which explicitly governs InfoSoc works and only InfoSoc works, is not the software directive, it's the InfoSoc directive, and it's got its own rule in Article 4.2, which gives effect to the treaty obligations in the WCT. Where then is the law? Because none has been identified. I've heard your Lordship's observations this morning about what might be inferred or not inferred from what the CJEU was saying in different judgments. But you have to go back behind and beyond that. Where is the provision by law that allows you not to protect InfoSoc works? And there isn't one, my lords. What's more, if you were to subscribe to the view that there was such a provision, you'd be joining the Supreme Court of Azerbaijan. There's a case called Safarov, which is in tab 51 of this bundle, It's referenced by the CAT in paragraph 173. And the Strasbourg Court found that a failure to give effect to the tangible products rule, which we discussed, amounted to a failure to protect the intellectual property rights of the right holder. You can't take away those rights in circumstances other than those which are prescribed by the statements and what we have in Article 4.2 of InfoSoc. Now, this is serious because these are constitutional protections for right holders. Now, you've heard arguments about spectrums of works. Well then, what are the legal criteria? Where do you find them? Is there any case law? There's no case law that I have seen cited. And the proof of that, if I can call it that way with no disrespect, is that your lordships are looking at judgments and observations in judgments with a view to inferring what is implicit or not implicit and making maybe deductions and so on. There is no case law at all for the spectrum of works analysis when it comes to the protection of works. Either they're protected or they're not. And there are no criteria that anyone can give you as to where on the spectrum it is. And the CAT was very wise. In Core Tab 12, paragraph 173, trying to find what page number is it, darling? 173. You're probably there quicker than I am, I'm afraid. Yeah, 173 is in bundle page 199. So at the top of the paragraph 173, they reference Safarov. European Court of Human Rights emphasised the importance of intellectual property protective measures under Article 6 WIPO. Exhaustion of the distribution right applies to fixed copies of works put into circulation. In that case, there was nothing to suggest that the rights owner had ever authorised its reproduction and communication to the public in a digital form. Microsoft emphasises the protection of property. That's all it says about Safarov, and then it goes on. Veal says that if we followed the approach which Microsoft argues for to consider each copyright work separately, the effect would be to emasculate the concept of exhaustion. In the context of a computer program, it suggests that most computer programs will incorporate artistic or literary work, so on. There may be some force in this submission, but we've not attached weight to it as an aid to construction. We cannot form a view as to what proportion of computer programs or parts of computer programs may incorporate such words. My lords, they are right to have said that. The construction of the legislation is according to the principles of interpretation of the legislation. It's not to do with any spectrum of the kind that's been argued with vigour by my learned friends here before you in this court. And that's why I'm a black letter lawyer on this. This is why I'm saying you must, with due respect, give effect to Article 52 of the EU Charter. You've got to find and locate these arguments in a provision of law. And it isn't, in my submission for reasons which I'm not going to weary you with again, it isn't possible on the interpretation of the legislation which occupies the domain. There was a point made in passing, so I'm moving forward, unless you want to press me on anything. I'm moving forward. There was a point made in passing on the Software Directive, Article 8. And my learned friend, Mr. Hicks, said, well, it says any other legal provisions. Well, you wouldn't think, I put it rhetorically, you wouldn't think that any other legal provisions is a form of words that needs interpretation. He said, but it doesn't refer to the InfoSoc Directive. Well, of course it doesn't. Those words started in Directive 91-250, 1991. The InfoSoc Directive wasn't promulgated into law until 2001, and they simply carried forward the old directive without making any change to it.
I don't have Article 8 in front of me. Any other legal provision, then it says such as,
Yeah.
it gives examples.
Yeah, it gives examples.
So it doesn't matter what point in time you apply it. Any other legal provisions
No,
which apply.
I'm just responding. The point was put against me. But I didn't mention this InfoSoc Directive. Well, I'm saying, well, of course it didn't.
Yeah.
It wasn't there to be mentioned.
That must operate from time to time. Legal provisions in force from time to time.
Always speaking. Any other legal provisions, national or EU, as a matter of fact. Right. Bear with me. So then I do want to spend a few minutes of my time reminding you that the PIs in this case were explicitly, both of them, crafted by reference to the distribution right and the reproduction right. Now, the framing of those questions occupied a fair bit of time this side of the bar to formulate it to make sure that everybody was satisfied that the arguments they wanted to run were encapsulated by the wording of the questions. And then we put it to Mr. Turner sitting as the chair alone, and he had some views of his own. He did a little bit of settling, but not much on them, but he was happy with the questions. Now, the point about it is we all knew, and it's still the position, how could it not be, that the reproduction right is engaged in all questions of exhaustion. And it couldn't fail to be in circumstances where you have the law, it's now really embedded, that uploading and downloading is an act of copying, reproduction. Even if it's transient, even if it's only en route to the making of a further end copy or something, and the whole mechanism that we're concerned with here is about actually a collision which has occurred between the distribution right and the reproduction right. And I need to explain a little bit more about that in view of the arguments you've heard. So, take the clear case of a CD-ROM. Sell it, over it goes, purchaser pays, gets the price. Purchaser gets the right to use, inevitably, of course, gets the right to use what's embedded or encoded in the CD-ROM, of course. Purchaser does not get any right to multiply and sell copies of it. This is the big transition that you get into when you move from the tangible copy analogy into the reproduction world. Now, reproduction is incapable of exhaustion. All rights of reproduction are reserved to the right holder. And UseSoft doesn't change that. Let's think for one moment about what UseSoft is talking about. First of all, the legislation itself gives you the words "that copy." The legislation itself, that's Article 4.2 software, so may we just in fact turn it up and see. Where is it? Authorities. Yeah, software directive. Tab 3. Oh, okay, I've got wrong bundle. Tab 3 in the authorities bundle.
Page 25.
Thank you, my lord. Thank you. The legislation sets the parameters. The reason they want to use this expression notional copy is because the mechanism by which the exhaustion occurs is when the purchaser pays the purchase price, is given the access key, and downloads from the right holder's website. The master copy is on the right holder's website. The copy, that copy, with respect to which there is exhaustion, is the clone of it, which is downloaded onto the purchaser's, wherever the purchaser wants to put it, as a matter of fact. I mean, we don't have to discuss client-server software. They can store it wherever they like once they've purchased it. Now, what the CJEU did, and it knocked people back when they did it, was they analogized the license consisting of you pay me and I'll give you access to it permanently and so on, you can have your copy. I call it analogized, I don't mind what the word is, they transmuted, it doesn't matter, they turned it into a sale. The Hotel Lutraki case is cited for that purpose. As I think I heard my Lord Sir Colin Burst say, it's cited for that purpose. Now, let me digress. We're familiar with this in English law. You may call it a license. The court may decide actually it's an assignment. You may call it a license. The court may decide it's a lease. We're all familiar with this. The label's not conclusive. You look at the substance of the transaction. Fine. Then they talk, so that's the license which gets elevated into the status of a sale. Then they use the expression user rights to describe the license you need, which has been reserved by the right holder, to allow the dissemination and multiplication of copies within your client organization. It's impossible to suppose that the licensed uploads, downloads and running for which you need permission under the reproduction right, it's impossible to suppose that each time that occurs, you're creating another exhausted copy, because you're not. It's not possible. Now, when Mr. Hicks, the transcript will show you that he moved and he moved back, and then I think he may have moved again. Sir Colin Bess put a question to him on this. He was saying that there are these two licenses. He said it more than once. There's the license to download and store, and then there's the license to run and operate at the workstations, etc. I think, did I get that right? No, I didn't get that right. Okay, well, I'm going to submit that there's the license which gets elevated, upgraded to the status of a transfer or a sale, and there are the licenses to use. Those licenses are not within the scope of the distribution right. The reproduction right can't be exhausted, and that is why the CJEU is respecting, through the block user right paragraphs in UseSoft, that is why the CJEU is respecting the right holders' rights to determine how many and on what terms there will be rights of reproduction in the periphery, aftermath, whatever, relative to that copy which has been downloaded. And that's why they're saying that the right holder can choose the number or the number of workstations. It doesn't matter how you get to it. And the right holder's decision is final. Now, to transfer that into a more commercial and logical situation, the purchaser, the second acquirer can acquire from the first purchaser that which the first purchaser acquired. What neither of them can do is go further up the chain and stand in the shoes of the right holder and reconstruct the transaction. It is not, well, you'd have to find some new law before you could say that. Now, just pausing here, I mentioned to you when I said to try and give it a tag for your memory that I'm not a heretic and I put stuff in the bundles to show it on. If you will please take the time to read those legal commentaries which we've included in the bundles. I'm just going to find the references to make sure it's there on the transcript for when you want them. It's tab 55, tab 56 and tab...
You gave them to us yesterday.
I did. Now,
So I looked at them at the time.
oh, did you? Sorry, it sounds impertinent. I don't mean that. As
Even
well.
I
It's
glanced
doubly
at them, Mr.
impertinent.
Holmes. I did glance at them. I'm not going to say I've read every word, because I didn't look at them,
My lord, I didn't quite catch that, but it
I
sounded
did look at them,
favourable.
you know, is what I said.
All right, okay. Just to,
I will look at them again.
well, and when you do, because they've got, especially Rosati, Professor Rosati, she won't like the expression, but I can use it. She's an eminence grise in this area. I mean, a very highly reputed academic in this area, and her book had the preface from Advocate General Spooner twice, and he spoke in glowing terms about how useful it was. You will, and von Lewinsky, Reinberter and von Lewinsky is from the Max Planck Institute in Germany, and she was part of the delegation, the German delegation that was involved in the negotiation of the WIPO copyright treaties. They know what they're talking about. And if you were to, when you refresh your memory with what's said in those texts, you will see that the argument that's being run here has no traction. There is no room for it. There is no sliding scale or spectrum of works. Why does he need it? Why do they need it? They need it because the truth of the matter is that, as I've submitted to you, there is concurrent and cumulative protection. It's provided, it's given, and it operates in that way. And then a friend dismissively a short while ago says, yeah, well, all right, so you've got a copyright here and a patent there and a registered design over there and so on and so forth, different things altogether. It doesn't apply, he said, when you're talking singularly about copyright. Well, it does. The whole point of my example to you about the Japanese prize-winning author was exactly to demonstrate the way in which copyright, if different species accumulates, right one on top of the other. And it's almost infinite. And you cannot escape the concatenation of rights in that way, or the collocation or combination of rights. You cannot escape from that by postulating that any one of them should be eradicated from the equation in a sort of Kremlin photograph style of erasing images that would otherwise be there to be protected. It's not an available option. Otherwise, you'll join the Supreme Court of Azerbaijan. I didn't hear, I don't think anybody said what the criteria are for the spectrum. I don't think I've heard. And I know there's no authority anywhere. I know there's no text, well, I know, insofar as I know anything about anything, I'm not aware of there being any suggestion in any commentary ever written for this argument that's been run before you. In Nintendo, I do want to nail down a point. You've seen enough text on it already. The Advocate General refers in her opinion to the court asking the parties a question. In the way of the court, they will send you before an oral hearing a question that the court requires answers from all concerned. It's a pretty solemn thing because the document has, you've got to vouch for what you're saying and you've got to substantiate it. And they asked a question as to which of the two directives are we concerned with here? Is it the program directive or is it the UseSoft directive? They asked that question. They had competing submissions from the parties, although maybe some of them were not so convincing as the others. It was essential for the court to rule on the question of which directive that they were working within the framework of for the purposes of deciding what technological measures protection they were going to implement. Now, in those circumstances, it's true that they weren't writing the law that goes with exhaustion of rights, but they were writing in the way which said you look holistically at the work without dismemberment or excision, which is what I submitted to you yesterday. The latest authority which reached the bundles, but I didn't get to it yesterday, it's after we did our skeletons, and it's a decision issued by the Court of Justice within, I'm guessing, the last 2 or 3 weeks, isn't it? It's Kalinescu. Can you give me the tab number? It's Kalinescu. In the paragraphs we've sidelined. Second? Tab 36. That was a case in which somebody had gone to the Harvard University Library to find a book which was, if it had ever been printed, was extremely rare, which dealt with the history of the Ottoman Empire, which had been written in the early 1800s. And they produced a critical edition. Well, of course, the work that was used as the basis for it was out of copyright. If it ever had copyright, it was out of copyright long, long, long ago. And they made it crystal clear that when you decide whether the work created by the person who produced the critical edition, whether that work was protected by copyright, you did not dismember it into the old bit that had been worked on and the new bits which had been added to create some form of subtraction process. You looked holistically at the whole thing. It's the best and clearest example I can give you to show you in modern case law that dismemberment and excision is not permitted. Which is not to say that by writing a critical edition over and in respect of an out of copyright manuscript from 1800, early 1800, resuscitates for copyright protection purposes the work that was produced way back then. It doesn't do that. But the question of whether it's protected or not comes out at the remedy stage, not at the stage of whether the work as a whole, the entire work, merits protection. This entire work doctrine is always attributed back to InfoPack, which we sent you this morning, and it was rightly adopted by reference to InfoPack in Nintendo, and it's clearly right. It was, my Lord Justice Green observed at one point, well, how fuzzy would that be if you let it all this tension come out at the enforcement stage? How fuzzy would that be? You'd leave people in a state of complete uncertainty and so on and so forth. And of course, I'm not going to say that there isn't any substance in that observation, I wouldn't say that. But now compare it with the test that you've been given, the spectrum test. That's as fuzzy as can be. I mean, that's fuzziness on stilts. It doesn't help. The only thing that helps is if you apply the law as written. And the law as written tells you, InfoSoc there, software directive there, different rules. Right, now I'm just about, yes, that copy and what they were talking about in UseSoft, I think we can all now agree that the UseSoft judgment is not a masterpiece in legal expression of the principles which they were searching for. I think we can all without hesitation agree that. There was a point that was made by my Lord Sir Colin Burse about the word if, used in para 69 of UseSoft. And I think the point was made if at the point of sale, the purchaser who buys the extra block only wants 2, then you read paragraph 69 in a certain way. My submission is this. It means if at any point in time, then what it says in paragraph 69 applies. And imagine what the alternative position would be, which was it's if at the point of sale, especially if you have a large corporate buyer of the kind we're dealing with here, in which you're getting tens of thousands of licenses. Whose intention? How do you deduce it? How can you ever find out later? It's unknowable. The rule is about if at any point in time there's an attempt to split the user right, that is breaching the restrictions and confinements imposed by the reproduction right. May I ask you to ask yourselves this? On the argument you've heard, why count anything? Why count anything? Every license, every workstation, why count anything? They all go free as birds, all exhausted, even though they weren't made by the right holder, they all go free as birds because they were made by the licensee with permission from the right holder. Reinboter and von Lewinsky have got paragraphs which are very clear on this, that the subsequent rights made with permission, the subsequent copies made with permission are not exhausted copies on any analysis of the law. I then reach the particular point that is being made by reference to UseSoft 3, with which, as you know, we disagree. This is where I will ask my learned friend, with your permission, for the opportunity to stand up. But just before I do, ask yourself this question. UseSoft 3 was in 2014. That's pre Art and All Posters, Nintendo and Tom Cabinet. Now ask yourself what that court might or might not have said if it had the benefit of those 3 CJEU judgments. Because nobody who has come back to this through the lens of those 3 cases has ever been able to just accept that with a wave of the wand that the UseSoft principle covers everything no matter what, that it all goes down in that particular direction under the software directive. Now, I believe that my learned friend has got some comments that he can... No? Have you? Yes. Do you mind if I just give way to him for just a few more minutes?
That's all.
The proposition that my learned friend sought to derive from UseSoft 3, from the headnote and all the paragraphs that he took court to, was that if the initial purchaser acquired a license that permits the use of several independent copies of the program, then the subsequent purchaser can invoke exhaustion for an arbitrary number of those copies. Of course, that all begs the question of what is meant by several independent copies. And even the BGH, my submission, requires an examination of the transaction as characterised by the agreements. The value of this decision is, in my respectful submission to my learned friend in the BGH, extremely limited, because as paragraph 3 makes clear, my learned friend took paragraph 3 in the course of his submissions, it relates to a specific Adobe membership agreement. We don't know the terms of that agreement, but it is clear from the judgment of BGH that a finding or indeed an assumption had been made that it did relate to these independent separate copies of a computer program. It was not a license. Paragraph 44, which for your note is on page 1015 of the authorities bundle, this is where my learned friend sought to make hay from the gloss that the BGH puts on UseSoft, and commented that it seems clearer than UseSoft in some respects. That may be so, but the gloss is no substitute for what the Court of Justice actually said, and one must grapple, in my respectful submission, with what the Court of Justice said, and not a gloss on it. The factual context of UseSoft was undoubtedly software which is installed on a server and on the workstations of the clients that access that server. Client-server software, your lordships will appreciate, is a portmanteau term. There is server software, and there's necessarily a client application to access the server. They connect, that's how they work. They're designed to be used together. Paragraph 45 then deals with the obverse proposition, and my learned friend placed great weight on this as the source of principle. That's page 1015 to 1016 of the authorities bundle. He said, if there are independent copies of a program, then you're entitled to resell. But it's quite telling in my submission to look at the authority side of that proposition. They're all domestic German commentators, dissenting domestic German opinions. There's no citation of the Court of Justice, there's no citation of any other authority or commentary outside of that context. I was instructed or exhorted to look at the German. What is interesting is that this is an agreed translation, I should make clear, between my learned friend and I. But the independent rights of use, which is referred to in that paragraph, the original German is Nutzenrechte, which is user right. So it's using that same phrase as from the CJU judgment, the user right. And so what it is saying is that the user right must be independently capable of use for each individual. And it's also apparent from paragraph 47, to which my learned friend did not take the court, that there was a finding on assumption, as I mentioned, that this membership agreement in question did not confer a block user right, but did confer 40 independent licenses, and that was said to be not challenged and in the Court of Appeal, and therefore not challengeable in the BGH. So its value is extremely limited for that reason as well. Interestingly, at the end of paragraph 47, there is mention of the assignment of a single serial number as implying the grant of a uniform right to use the software. But it said that it couldn't even consider that argument because it's inadmissible for the aforementioned reason. Now, in this jurisdiction, we would treat this question as one of construction, because during the license, question of law. So, again, the decisions of limited value. On the provisions of the agreement.
Is it a question of law or is it a question of fact?
Well, one has to construe the words of the license.
Yes, that's a question of law.
That's a question of law. And that is what tells you what the nature of the right is, the user right.
Well, exhaustion can't be contracted out of. So I'm not sure it's as simple as saying that it's just all a question of the law reading the licenses.
Your Lordship is entirely right. It is, of course, an autonomous rule, I think we all agree. And it is not a question of what the parties say solely in their contract. But when the autonomous rule points you to examine the substance of the transaction and says also that the license is indivisible from the copy, it inevitably points you to look at the contracts by means of which the transaction is effected, to understand what they mean. That must be the input to your analysis. Now, if I'm right that the tribunal made errors in its analysis of the contract, that vitiates any subsequent conclusion on that issue.
Okay.
So the copyright must be consistent in every case across the EU because it comes from an EU directive. The way in which it's thereafter commercially exploited by license or by contract may be different.
Yes.
And that might need to be construed in order to determine quite what rights were given to a licensee and therefore when they were first sold, what was exhausted.
Yes.
Exactly so, respect. So that's why the position for
The
the
concept of exhaustion and so on is an autonomous EU.
Right. The principle is autonomous, and then how it relates to a particular transaction has to be determined in the context of that transaction by reference to its terms. And of course we know that the directive does not harmonise the law of contracts without prejudice to that. So that's a matter for national law.
Well, subject to the fact that you can't have provisions in a contract which would undermine the concept of exhaustion.
Quite right, but no one is suggesting that the mere grant of the block is in that territory. That's just the character of what's granted. Before you even get to the question of whether there is exhaustion, and to what extent. Just on the terms of the contracts that my learned friend took you to very briefly, he accepted, I think, there's a question of substance, not form, when analysing the nature of the bargain. But his major point was that the customer thinks they're getting a bundle of licenses because they see the label volume licensing in the header of the documents. He sought to make the argument that the defined term license is what tells you that it may mean multiple licenses. It's essentially the plurality point again. But the answer to that is that the defined term license is the user right, the very thing that the Court of Justice says you can't split and resell as a bare right, absent, decoupled from the copy. So one must always analyse whether the user rights are independent, even if we are applying the approach of the BGH, for example, in UseSoft 3. And we say if one looks at the contracts here, the answer is clearly no. That's the nature of grant. Finally, my learned friend postulated the net number of copies test, and there was some discussion in argument with the court about what would happen if there was a 10-user block with one server copy and 10 users, and that first acquirer wanted to transfer 5 user rights to a second acquirer who already had their server copy because they were an existing customer, but they wanted 5 extra user rights. And my learned friend said that would be totally fine because there's no net increase in the number of copies. Just breaking that down, the risk of stating the obvious in 1 minute. Before resale, there are 2 server copies. One from the first acquirer and the second acquirer's copy that he already has. After resale, there are indeed 2 server copies. Before resale, there are 10 users accessing the server of the first acquirer and however many accessing the second user. After resale, there are 10 users accessing the server of the first and second acquirer plus whatever there were originally for the second acquirer. So yes, it is indeed net neutral. And yet what does the CJU tell us at paragraph 71? Exhaustion doesn't let you resell and augment the user right in that way. So his example doesn't work. In fact, it shows exactly why this test is wrong. Because the very thing that he says should be fine is exactly what the Court of Justice says in terms at 71 is not permissible. As for the sample transactions, obviously I didn't have time to address your lordships already on them. One point my learned friend made was that what paragraph 106 of the judgment below said on the evidence, there's no evidence to support the suggestion that the first acquirers have not deleted or that there's a greater number of copies in existence. Our ground two is that that's inverting the onus of proof under ranks, paragraph 56. That was wrong in law to make that assumption in favour of the person relying on the exhaustion rule. It's for them to prove that, and the tribunal didn't engage with that question. Unless I can assist you further.
Thank you, Mr. Reardon.
I'm not going to. Good. I'm just going to say a couple of polite things. My clients have asked me to ask you please to keep in mind what's in paragraphs 1 and 13 to 15 of our skeleton. We never stop supplying them. They could have used the PLTF procedure anytime they like. It's free of charge. and they'd have had complete clearance. We didn't pick this fight, they sued us for damages. My clients just want you to understand that dynamic.
Thank you.
Then the second thing is this, none of us this side of the bar would wish to see a judgment in which it was said that the court didn't get the assistance it required from counsel. If there is anything at all which you find in your deliberations you'd like some assistance from us, please let us know. No, you must. I mean, it's awful to be receiving a judgment like that. It comes in and says, I could have heard more and better from counsel when you could write. And then finally...
Last time I sent you a draft judgment, which is probably 10 years ago, you sent me a long list of homework to do.
I know, but my lord did it.
I know.
It was a productive exercise, so I'm mutual gratitude. Pardon?
Not on my part.
No, the Court of Appeal upheld you. Sorry, it's getting too personal.
I was in the middle of a murder trial in Sheffield, and I had to stay up almost all night to do the
Right,
amendments.
I didn't know that.
Yes, I still hold the grudge.
Right, okay.
I'd stop thinking if I was you, Mr.
Yes. Right, so it just remains for counsel to thank your lordships for your care and patience in dealing with this matter. Thank you.
Well, it's very kind of you to thank us, Mr. Hobbs. I was going to say the same about you. I'm very grateful. We are all very grateful to you, to all counsel, also to the people behind you for all the work that's gone into this. You've given us a lot to think about. We will reserve our judgment. I'm sure you're not surprised to hear that. I'm not going to give you a promise about when it will come out. What I will do, though, is say that we will try and at least give you some warning about when it might be coming, rather than just you getting the first notice you know the judgment is coming, an email saying here is a draft judgment. So with any luck, you'll get a couple of weeks' notice at least, if not a bit more, but we'll just see.
Right.
Of course, we can't promise when I say,
No.
if we tell you that it's going to come out in a
Yes.
couple of weeks, it may not,
Yes.
but we will try and do that.
Thank you. Might I, with no impertinence, ask whether you might be envisaging that it'll be a single judgment on both appeals or separate judgments on the two appeals?
Until you asked that question, I had thought it would be one judgment on both appeals.
I understand.
That hadn't actually occurred to me, so
No, I understand perfectly. Thank you.
we'll see. Okay,
That's it.
thank you very much.
Thank you.
Court rise approval.